Question. Discuss the power of the Supreme Court under Article 32 to issue writs like Habeas Corpus and Mandamus to protect fundamental rights. Hello friends. Today we will discuss one of the most powerful provisions in the Indian Constitution, Article 32, which is often called the heart and soul of the Constitution. This article gives the Supreme Court the power to issue writs for the enforcement of fundamental rights. Article 32 is not just a procedural provision. It is itself a fundamental right. Dr. B.R. Ambedkar described it as the heart and soul of the Constitution because without the right to approach the Supreme Court for enforcement of fundamental rights, all other rights would become meaningless. It empowers every citizen to move the Supreme Court directly when any of their fundamental rights are violated. The Supreme Court can issue 5 types of writs: habeas corpus, mandamus, certiorari, and quo warranto. Let us understand the 2 most commonly used writs mentioned in the question. First is the writ of habeas corpus. It is a Latin term meaning you may have the body. This writ is issued by the Supreme Court to secure the release of a person who has been illegally detained or imprisoned. It is a powerful safeguard against unlawful detention by the state or any authority. The court can order the detaining authority to produce the detained person before it and justify the detention. If the detention is found illegal, the person must be released immediately. Habeas corpus is considered the greatest safeguard of personal liberty. Second is the writ of mandamus. It means we command. This writ is issued to command a public authority, government officer, or lower court to perform a public duty that it has failed or refused to perform. It cannot be issued against private individuals or against the president or governor in their personal capacity. Mandamus is used to enforce statutory duties and to correct administrative inaction. The Supreme Court has used these writs in many landmark cases to protect fundamental rights. One of the earliest and most important cases is A.K. Gopalan versus State of Madras in 1950. Although the court took a narrow view at that time, it laid the foundation for future expansion of Article 32. The real breakthrough came in the Maneka Gandhi versus Union of India case in 1978. The Supreme Court gave a broad interpretation to Article 21 and held that the procedure established by law must be fair, just, and reasonable. This judgment greatly strengthened the power of the Supreme Court under Article 32 to issue writs for protection of personal liberty. In the case of Bandua Mukti Morcha versus Union of India in 1984, the Supreme Court used the writ of habeas corpus in a broader sense. It treated bonded laborers as being illegally detained and ordered their release and rehabilitation. This case showed that habeas corpus can be used not only for physical detention but also for exploitation and bonded labor. In the famous Husainara Khatun versus State of Bihar case in 1979, the court used Article 32 and the writ of habeas corpus to secure the release of thousands of under-trial prisoners who had been languishing in jails for years without trial. The court held that speedy trial is part of the right to life under Article 21. For the writ of mandamus, a classic example is the case of S.P. Gupta versus Union of India, judges transfer case in 1981. The Supreme Court issued mandamus to enforce transparency and accountability in the appointment and transfer of judges. Another important case is Vineet Narain versus Union of India in 1998, where the court issued continuing mandamus to monitor the investigation in the Jain Hawala case and laid down guidelines for the functioning of the CBI to ensure its independence. These cases show how the Supreme Court has used its power under Article 32, not only to protect fundamental rights but also to enforce socio-economic justice and good governance. The main characteristics of Article 32 are: it is itself a fundamental right. It provides direct access to the Supreme Court. It is a part of the basic structure of the Constitution, as held in Kesavananda Bharati. It cannot be suspended except during emergency under Article 359, and it empowers the court to issue any direction or order it deems necessary for enforcement of fundamental rights. Friends, Article 32 is the guardian of all fundamental rights. It gives teeth to the fundamental rights guaranteed in Part 3. Without this article, the fundamental rights would remain mere paper rights. The Supreme Court has used this power creatively through writs like Habeas Corpus and Mandamus to protect personal liberty, secure speedy justice, fight bonded labor, ensure transparency in governance, and promote human rights. This provision truly makes the Supreme Court the protector and guarantor of the basic rights of every citizen. In conclusion, Article 32 is not just a technical provision but the very soul of the Indian Constitution. Through landmark judgments from A.K. Gopalan to Manika Gandhi, Husainara Khatun, Bandua Mukti Morcha and Vineet Narain, the Supreme Court has expanded its scope and used the writs of habeas corpus and mandamus effectively to protect fundamental rights and deliver justice to the weakest sections of society. It remains one of the strongest pillars of constitutionalism and judicial review in India. As long as Article 32 exists and is zealously guarded by the Supreme Court, the fundamental rights of Indian citizens will remain safe and meaningful. Jai Hind. Jai Bharat.